Court rise.
Hearing in the appeal, the Queen on the application of JS Sri Lanka against the Secretary of State for the Home Department.
Yes, Mr. Rankin.
My Lord, I'm grateful. My Lord, I appear on behalf of the Appellant Secretary of State in this matter with my learned friend Mr. Dillon. My learned friends Mr. Singh, Ms. Jagaraja and Ms. Butler appear for Ms. JS, the respondent in this matter. Your Lordships, perhaps just a brief matter of housekeeping before I start. Your Lordships should have had the core volume and the volumes of authority. Your Lordship will find on your desks a slim, I hope, but inevitable bundle of supplemental authorities, which include, just for your Lordship's information, the case of In Re B about civil standard of proof. I may not need to go there, but I thought it prudent to have it available for your Lordships if we do. The case of Al-Siri in tab 123, which also considered the question of standard of proof in relation to serious reasons for considering. And finally, in tab 124, a complete extract from the book of Graal Madsen, which your Lordship have in extract in volume 14 at tab 104, and all the insert in 124 is a complete version of that.
Thank you very much.
As your Lordships will be aware, this is an appeal on a point of law from the Court of Appeal in the context of judicial review proceedings, in circumstances where the Court of Appeal heard the substantive judicial review as a court of first instance, and in circumstances where none of the fundamental issues now before this court, such as the adequacy and correctness of the test proposed by the IAT in the case of Gurung, were in dispute before the Court of Appeal. So we are in one sense in an unhappy position that this is the first time that there is oral argument on Gurung and on whether it provides proper and correct guidance as to the application of Article 1F.
I thought Lord Justice Toulson went to some lengths to explain why he wasn't very happy with Gurung. You're suggesting the point wasn't really developed in argument before.
No, my Lord, I'm not seeking to take a point on it, but what I'm seeking to explain is that, as your Lordship will see from the decision of the Court of Appeal, the respondent in this matter did not challenge Gurung as being setting down the proper guidance and being applicable. His Lordship, Lord Justice Toulson, then invited the parties to comment on the case of Krasnic in the International Criminal Tribunal for the former Yugoslavia, but without indicating in any way that Gurung was going to be questioned. I'm not seeking to raise it, make an issue out of it, but what I'm seeking to set is the background. That one of the reasons why I fear some of the arguments have been as broad as they have been in this court now is because there hasn't been fully developed legal argument as there would have been, oral legal argument as there would have been, if it had been heard at first instance in the High Court as a substantive JR, on appeal to the Court of Appeal, where the issues would by necessity have been refined again, and then coming to this court.
I mean, paragraph 93 in the Court of Appeal, page 28 of the appendix, does start by saying that the respondent counsel, then of course the appellant's counsel, didn't on the surface challenge the guidance given in Gurung.
My Lord, yes.
That's your point.
That's my point, my Lord.
I mean, it was a one-day argument in the Court of Appeal, as far as I can see.
My Lord, yes, that's right.
So I wondered whether it had been possible to go into all this stuff in as much detail.
My Lord, no, it wouldn't. But the reason for that is, and only by way of background I raise it, is because it wasn't an issue.
Yes, it had been dealt with very briefly at first instance, a very short judgment.
My Lord, on permission, yes, but not as a substantive argument.
And can I just understand the shape of your argument? One point that struck me was that there's quite an obvious gulf between you and Mr. Singh. I have the impression that you don't get into the ICC articles to any extent. I mean, you mentioned near the end of your written case, whereas Mr. Singh takes us pretty well straight away to the ICC articles and the ICCY and so on. Is it as sharp a division as that you say we shouldn't look at these
No, my Lord.
these rules such as they are, or
No, my Lord. The Secretary of State's case is in relation to the relevant international instruments under Article 1FA is that they are all relevant. That is starting with the London Agreement that set up the International Military Tribunal in Nuremberg,
yes,
running through all the way to what is now the most recent of those instruments, which is the Statute of the International Criminal Court. But
yes,
not that one is to be given preference to the other, but that they all have equal validity, and that the emphasis is, in the article, is on international instruments drawn up in respect of such crimes, rather than international criminal law. Yes.
I mean, if the Secretary of State didn't reach the point of concluding there were serious reasons for considering that he would be convicted before the International Criminal Court, are you saying he can still falls foul of 1FA?
My Lord, what we're saying is that in relation to the standard that needs to be applied is that there need to be serious reasons for considering that he is responsible for a crime illicit in the way the courts have interpreted the relevant...
I know, but in the way interpreted so as to bring home a conviction before the International Criminal Court? Or could he be acquitted by the International Criminal Court but still fall foul of 1FA because, you say, you're entitled to take a larger approach, so to speak, than the ICC?
My Lord, yes, but the Secretary of State's position is that the Article 1FA and the directive deliberately chose the phrase serious reasons for considering, and that leaves open the possibility that there is material on which that conclusion can be reached, even though it may not be sufficient, ultimately, for a conviction. So it's not seeking to import a criminal standard into...
No, I follow that, but I'm not really asking about the standard. I mean, he's got to have serious reasons for considering that he's committed a crime, but does it mean he's got to have serious reasons for considering that if he were in fact then tried with all the evidence then available before the International Criminal Court, he would be convicted? Or isn't that a relevant question? Or I would have thought that on the face of it, isn't that a very important question? Would he or wouldn't he ultimately be convicted before the ICC? Because they're concerned principally, are they not, with these war crimes and crimes against humanity?
My Lord, yes, of course. The emphasis needs to be on the Secretary of State considering whether he would be, on the material available, capable of being convicted.
By that court?
My Lord, by a court.
Well,
because
according to the standards laid down by that court?
Well, my Lord...
Or you say no? All right.
No, because we say, and that's where I think the dividing line is, that all these instruments are relevant, and that includes the Geneva Conventions and the instruments adopted in the intermediate term, not all of which are necessarily subject to that jurisdiction, but may be tried elsewhere. So it's not by reference to a particular court. And of course, in relation to the ICC, we don't currently have... we have the statute, but we have no case law which helps us develop how they will approach their very different terms of reference than the International Criminal Tribunal for the former Yugoslavia, in relation to whom, of course, we have detailed case law on the concept of joint criminal enterprise, to some of which I will need to take your lordships.
But is it to reach the standard of a case to answer? I mean, a case that it can be responsibly brought by way of prosecution in a court, or is it something lesser than that?
My Lord, in our respectful submission, it is not focused on evidence, and therefore, in one sense, it is lesser, but only because it refers to serious grounds for considering and makes no reference to the need for evidence or even to admissible evidence. And one of the reasons for that, we would submit historically, is that it was intended to be give member states or contracting parties a wide discretion to exclude people in order to enable the war crimes trial process to take place, even if that evidence is not currently or to that decision maker available. Because, of course, this was drawn up at a time just after the Second World War, and was focused at a time where the responsibility for the different decisions lay with very different people, and in this sense, with the national decision maker, primarily the executive, subject to, though not compulsory, subject to supervision by the courts of that member state, while the interpretation of the London Charter, or the London Agreement, which was in force at the time, of course, lay primarily with the International Military Tribunal in Nuremberg and its equivalent in Tokyo, and the court set up by the Allied forces in order to try war crimes, in particular in Germany.
I haven't followed the detail sufficiently to know the answer to this, but if somebody was given asylum, does that mean that he or she cannot be brought before a court tried with a war crime? Are they necessarily inconsistent with each other?
My Lord, they are not necessarily inconsistent, even though, of course, a refugee is protected from removal to some extent by Article 33 of the Refugee Convention, which I don't think your lordships have in the bundles, in 32 and 33, in relation to extradition, in relation to removal to the country from where they came. And of course, again, looking at it historically, the individuals who would have been granted that kind of asylum would have to be returned to Nuremberg to face trial before the IMT or to one of the other Allied courts, largely sitting in Germany. And therefore, historically, that may well have produced difficulties.
Thank you.
But you said that he doesn't need to have evidence.
My Lord, I want to be careful. He does need to have sufficient material.
Not admissible evidence.
Not admissible evidence.
I'm just asking,
my
that's your
Lord,
position.
He needs to have sufficient material on which he can rely to make that decision, my Lord, yes. And once that material is there, and we will see through the case law, as happened in this case, that of course, quite frequently, the material in relation to the organisation we're concerned with is material that is publicly available, as it was in this case. And in the asylum context, very frequently, the only information that makes the link between the individual and the organisation is the individual's evidence, or the evidence the individual gives himself. It is a much rarer case, and usually relates to the most high-profile war criminals and the like, that there is independent evidence which can be adduced. And that, of course, in a sense, is what happened here. There's a lot of material about the LTTE set out summarised in the War Crimes Unit report, which recommended his exclusion, which your lordships have in the core volume. The basis of the exclusion was the way his evidence, his statement to the Secretary of State, linked him into that evidence on the LTTE and its intelligence division.
So it's the interview, which I think is at pages 117 and onwards in the appendix.
My Lord, yes.
Is that it? And coupled with the broader information about the activities of the LTTE.
Yes, I mean, your Lordship will see how it's structured in the War Crimes Unit Case Research and Analysis Report at page 410 of the core volume. 410, my lord. 410.
Yes.
Your Lordship will see this relates to Mr. JS.
Yeah.
It summarises the facts in the bullet points under the heading the facts, and your Lordship will see that all the cross-references in the footnotes are to
Oh, I see.
the CEF, which is the document your Lordship referred me to, which is the Statement of Evidence form, which starts at page 113 of the core volume. And it is that evidence, which he himself gave, which then links him into the evidence of international crimes, which is then set out extensively over pages 411 to 414 in relation to the LTTE itself.
I mean, there seems to be a rather sort of odd but profound disagreement between the parties as to whether, I think you call it, there's a unit called TOSIS, Tiger Organisation of Security and Intelligence Services, whether that's a unit within the intelligence department of the LTTE. You suggest that the two are coincident, as I understand it.
Yes, my lord, as we understand it, and it's in the sense that that's the difficulty with that. It's a question of fact, but as we understand it, or as I understand it, is that the intelligence unit is or the Tiger Organisation of Security Intelligence Services is a subunit of the LTTE, which itself is then subdivided into combat units and the like, of which we know he was in charge or second in command at one stage of the combat unit of that intelligence unit.
Yes, but is TOSIS the same thing as the intelligence division or a subunit?
My lord, as I understand it, it is the same thing, but if your lordship will...
But I mean, the respondent, as you, I'm sure, appreciate, says absolutely not. At least that's how I understand page 46 of the respondent's case. He picked, because your paragraph 7 treats it as the same. Your paragraph 7 at page 6. You say not merely a member of LTT, a member of TOSIS,
So, my lord,
described as the intelligence division. Compare that to page 46 of the respondent's case. Do I mean 46? Let me just look. 45.
My lord, is it 45, page power 108?
Yes, 40, that's right, page 45, not 46.
No evidence. Yes, it's paragraph 108, is it?
108, he says there's no evidence at all which suggests that he is a member of that.
But my lord, even there, even the way the respondent phrases that is that the Tiger Organisation of Security Intelligence Services is also known as the intelligence division of the LTTE. And of course his evidence has been that he was a member of the intelligence division, of a particular subunit of the intelligence division of the LTTE.
Well, he was at one time a member of the combat unit. I think that's common ground.
My lord, yes, but it's the combat unit, as we understand it, the combat unit of the intelligence division.
Yes.
The combat group of the intelligence division.
That's right. First he was within that as a team leader of 9, and then he returns to that and becomes its 2IC in 2004.
Yes, my lord.
Second in command.
But as on that basis, I did not understand the disagreement, and if it is, it's a question of fact which I will need to take some instructions on. I did not understand the disagreement to be that TOSIS is different from the intelligence division. And I must say, we were somewhat puzzled by the suggestion that where he had said he was a member of the intelligence division, was transferred to the intelligence division and then worked in the combat unit of that intelligence division, that was an issue of fact that was being raised now.
Well, I mean, your para 7 and paragraph 108 are simply irreconcilable, aren't they? I mean, they can't both be right. I mean, you say LTTE and TOSIS are all the same, and he says no, there are these various units, and the ones he was in, combat, mobile, bodyguard, but never TOSIS.
My Lord,
At least that's how I understand the factual dispute arises.
my Lord, on the evidence as it is presented, the Secretary of State's case throughout has been that he is a member of the Intelligence Division. It is our understanding that TOSIS is an acronym for, or the full name of, the Intelligence Division. And as a matter of fact, that is the basis on which that case was founded.
The agreed statement of facts and issues doesn't touch on this point, I think.
No, my Lord, it doesn't. And again, but the agreed statement of facts and issues, of course, records that he would lead a mobile unit of the Intelligence Division. Yeah. So if we look at paragraph 1 on page 2, he joined the Intelligence Division and received training in intelligence and further military training. He then joined the combat unit of the Intelligence Division and saw military action as a platoon leader. And then he was appointed to lead a mobile unit, so moved from one unit of the Intelligence Division to the other, a mobile unit of the Intelligence Division, responsible for transporting military equipment and members of the Intelligence Division by foot from Vanni through jungles to settlements close to Vavunija, from where the members of the Intelligence Division were sent to Colombo wearing civilian dress. And he then became a chief security guard of the leader of the Intelligence Division. And
one of the chief.
One of the chief security guards. And then in paragraph 5, he returned to the mobile unit of the Intelligence Division and resumed responsibility for the supply of military equipment to plan. And ultimately, from 2004 to 2006, he served as second in command of the combat unit of the Intelligence Division. So it had always been the Secretary of State's understanding of his evidence, and that is reflected by the agreed statement of facts and issues, that he was at all times a member of the Intelligence Division. And it is further the understanding of the Secretary of State that TOSIS is the acronym for, or the full title of, that Intelligence Division.
Well, I mean, it's quite important, it seems to me, to be clear, because, I mean, on the face of it, there is this issue between you as to that. I mean, as I understood it, certainly as I understand the respondent's case, when you're in the ID, the Intelligence Division's combat unit, you're in uniform fighting, the other army. Do you not accept that?
My Lord, on the evidence, I have no basis to accept that he would necessarily have been in uniform when part of the combat unit. In a sense, there is no evidence as to how the combat unit of the Intelligence Division, what role they would have played in combat. But of course, we do have photographs of him in uniform. So there's also no basis to say that he doesn't. But certainly his other roles, he performed as while in the mobile unit, for example, and before he joined the combat unit, are all. There is no evidence in how far that was part of when that was part of kind of traditional form of combat of uniformed soldiers against an insurgent force, or whether that was activity not in uniform or not in accordance with the laws of war or or the like. And we have significant evidence, which is set out in the War Crimes Report, which your Lordship have seen, starting from page 414, of the activities the intelligence unit of the intelligence division of the LTTE, led by Potu Aman, who's the man to whom he was one of the chief security guards, was the activities they were involved in.
Sorry, which page?
This is starting at 414, right at the bottom, my lord. And your Lordship will see at the top of 415 that it comes under the command of a person commonly known as Potu Aman, who is the person to whom he is one of the chief security guards when they go and see one of the senior commanders of the LTTE.
Is the organisation, beginning of the second paragraph on page 415, that is a reference back to TOSIS, is it? The organisation includes a large number of departments.
So, my lord, this is the second.
Second paragraph,
Yeah.
beginning a third of the way down, page 415. I think it must mean TOSIS. You see that? It includes a large number of departments, including military intelligence, intelligence-backed tigers, explosives training, and so on and so forth.
Yes, my lord, that's what I understand as a reference to TOSIS,
Yes.
having those sub-departments, rather than the LTTE having those
Yes.
sub-departments.
Well, I mean, you say that the combat unit, is just, is it listed within these departments?
It is not listed within these departments, my lord, no. But it is understood to be one of the departments of the intelligence division. As I understand it, his further witness statement made shortly before the hearing in the Court of Appeal confirms that almost all the divisions of the LTTE had their own combat units. This is at page 107, paragraph 5. To ensure that there was healthy competition between these combat units, and in order to maintain a high level of efficiency.
And the combat units are what? Just like any other combat unit of LTTE? I mean, because I can't remember where it's all set up, probably in the respondent's case, but you know, there it is. They run their own army, Air Force, Navy, police, everything else, in various parts.
My lord, they do, but the evidence the Secretary of State has and relies on is that set out in the War Crimes Report, and that does not make reference to the activities in detail, to the activities of the combat unit as such, or the mobile unit of the intelligence division. But it records the activities the intelligence division was engaged in, and of course his evidence is that he moved through various departments, and one of the things they are reported as doing is, for example, facilitating the deployment of suicide bombers, which we see at page 416 through to 417, and over the page really to the end of that bullet point. And the recruitment of child soldiers at 419, and the like. And it is tying. The Secretary of State's case is based on that evidence about the activities of the intelligence division of the LTTE in all its guises, or encompassing all its subdivisions, in relation to which the Secretary of State has made his case, that on the basis of that evidence and his evidence as to his role within that organisation, there are serious reasons for considering that he committed, not personally, but through the application of the concept of complicity, as it's referred to quite frequently in refugee law, joint criminal enterprise and criminal law, responsible for war crimes and therefore subject to mandatory exclusion under Article 1FA.
Is that because he was aware, you say, that in the ordinary course of the operations which he was contemplating, attacks of that kind would be carried out?
My Lord, yes. The case is that he had the necessary knowledge of the activities the intelligence division would have been involved in through various means. One is his long-term engagement in the unit, which of course includes him joining as a child, and your Lordship will see that recruitment of child soldiers is one of the issues that arises as a potential war crime. But also, of course, through the fact that he is, according to his own evidence, he was at a meeting between the leader of the intelligence division and one of the senior leaders of the LTT, Colonel Karuna, who later split from the organisation, but that was after JS left. He acted as an intermediary at a meeting they had where they were sitting so far apart that he conveyed their messages. And through all that involvement, and his involvement as a security guard at that meeting, his involvement as a leader of first a group of 9 and then a group of 45 and then second of command of the combat unit, he would have had the requisite knowledge.
The most direct and immediate account of what he was actually doing between 1996 and 2006, it seems to me to be the interview record, starting at page 133, question 31, down to page 136, question 54. And that's quite a lot of questions and answers. But the general impression that gives, rightly or wrongly, it seems to me to be of someone engaged in warlike activities and probably wearing uniform. But and it covers also the meeting with Colonel Karuna as there at questions 46 to 49.
My Lord, yes, it does. And of course, there is, but there are the instances reported. For example, questions 46 through to 49, which relate to his role and his contact with Potu Aman and yes. Colonel Karuna, and yes. the way he acted as an intermediary. And of course, and that is one of the reasons why I started by taking your Lordships to the background of this case, that it starts as a judicial review. It didn't come here by way of an appeal to the AIT, where that evidence could have been tested in some detail, but it comes on the basis of a judicial review where, in my respectful submission, the question for the court below was whether A, the Secretary of State applied the wrong legal test, and B, if not, whether his conclusions were challengeable on public law grounds. And it isn't, and there hasn't been, the testing of the factual evidence, which would raise all the questions your Lordships have put to me. But of course, that is not how the case came here. If the respondent had waited until he had accumulated a year's worth of humanitarian leave, he could have, under the 2002 Act, appealed to the AIT, and then this case might have come to this court via that route, and your Lordships would have been supplied with, no doubt, a much more detailed and much more tested account of his role. All we have here...
I'm lost. Just tell me that again. You have to have a year's... He got a 6-month leave, as I understand it.
My Lord, the position is that in order to have a right of appeal, the decision made by the Secretary of State must be an immigration decision under Section 81 of the 2002 Nationality, Immigration and Asylum Act. Now, that decision, a decision refusing leave to enter as a on asylum grounds, but which does not leave the individual without any leave, is not such an immigration decision, because he has in effect been given leave, though not the leave he sought. But for asylum applicants in particular, and in recognition of the fact that, of course, the Convention brings other benefits than just a right of residence, Parliament in Section 83 of the 2002 Act has provided that where somebody has applied for asylum and asylum has been refused, and he has been granted leave for periods less than a year, after he has been granted a year's leave, or he has either singularly or cumulatively, he can then appeal against his refusal for asylum, or his refusal of asylum.
Has he been getting consecutive 6
My Lord,
months?
yes.
I see.
But the route to the courts the respondent chose was to judicially review the original decision. For that decision, there is, under the 2002 Act, no provision for a right of appeal, which means the evidence as it is has not been tested through cross-examination, and it also means, in my respectful submission, that the test to be applied by the Court of Appeal, or whichever court as first instance hears this matter, and therefore that must inform the approach of this court, is the legal test is a different one. And the legal test is a typical judicial review test on public law grounds.
Well, thank you very much. We've asked you a lot of questions. I don't know whether you've been taken completely away from the way you wanted to present your case, but perhaps it might be helpful if you set out your stall
Yes, my Lord.
now, so that we see what the formula is that you wish us to follow.
Yes, my Lord. I have. I mean, this has dealt to some extent with the issues I wanted to open with. But the way I was proposing to take this case, and again, the questions your Lordship have helpfully posed has done some of that, is to start off by going to the decision letter and the war crimes report. And we've been to the war crimes report, so I can take that more shortly than I might otherwise have had to. And then to the decision of the Court of Appeal to see also what factual submissions the Court of Appeal accepted and what was, in effect, the sole issue before the Court of Appeal, and then to set out, or to take your Lordships to the disagreement expressed by the Court of Appeal with the approach in Gurung and the alternative test the Court of Appeal appears to be proposing. Having set the scene, I would then propose to take your Lordships to Gurung, because that seems to be, is in a sense, internationally recognised as, certainly in English law, the core authority, and the approach taken by the Immigration Appeal Tribunal in that context. And from there, branch out to look at the cases Gurung looked at, so the three oldest Canadian cases, Ramirez, Moreno and Sivakumar, and take your Lordships to the London Agreement, the International Military Tribunal, and the recent case law on joint criminal enterprise, and so the approach to those international agreements. Take your Lordships to the different wording of the ICTY statute and the ICC statute, and then afterwards look at the one or two subsequent cases in Canada and two cases in Germany, which we say are relevant, perhaps particularly relevant at this point, because of course we are not only concerned here with the interpretation of Article 1FA, but we have to do so in the context of Article 12.2 of the Qualification Directive, which since October 2006 provides the European law, European community law framework for the determination of refugee status, and which in terms akin to 1FA, provides for a mandatory exclusion from refugee status.
Where, Mr. Knapp, do we find the briefest summary of your position as to what the test is? I mean, do you say it's Gurung, or do you say, what do you say? Where do we find it? It's in your...
Well, my Lord...
I mean, I find a lot of criticism of things and so on, but I just wondered, can you give us a short summary or whatever?
Perhaps I can do that. There two things. Essentially, the Secretary of State's starting point is Gurung. And therefore, the Secretary of State's position is that where there's an organisation which has been engaged in war crimes and crimes against humanity, it is membership of that organisation is not generally enough to exclude an individual from the benefit of being a refugee under Article 1FA, under 1A of the Convention or of the Qualification Directive, unless there is evidence that he was a knowing participant or accomplice.
One's talking about voluntary membership, of course, isn't one?
My Lord, yes.
Which we have here.
My Lord, which we have here.
Unless he was a knowing
Participant or accomplice.
or accomplice.
And my Lord, and we then draw out two distinctions which reflect, we say, the graded approach of the IAT, which of course was designed to aid the decision maker in what is ultimately very much, we would submit, a question of fact, namely whether there are serious reasons for considering. But reflecting that gradation, that there are then two subtests, or two possible categories. One is where an organisation has what the Canadians refer to as a limited brutal purpose, and which Gurung referred to as a organisation who was predominantly terrorist. That, we would say, raises a rebuttable presumption that a person who was a voluntary member was a knowing accomplice in the war crimes or crimes against humanity committed. And secondly, where the organisation does not fall within that category, in deciding whether a person falls to be excluded as a knowing accomplice, the decision maker would have to consider factors such as, and there are 6 of them, the nature of the organisation.
Sorry, just take it a little bit more
Sorry.
clearly. Necessary to consider 6 factors.
My Lord, yes. The nature of the organisation, the method of recruitment.
Not too fast, please.
Sorry. The nature of the organisation, 1. 2, the method of recruitment. 3, the opportunity to leave, both 2 and 3, of course, going to the voluntary nature of his membership. 4, the position and rank in the organisation. The length of time in the...
Is this 5?
Sorry, 5 now is length of time in the organisation, my Lord. And 6 is knowledge of the organisation's war crimes or crimes against humanity. Or as the courts below have referred to it, knowledge of the organisation's atrocities.
And if you tick all these various boxes, what does that lead to?
Well, my Lord, of course, none of those necessarily allow for yes or no answers. None of those are necessarily tick box answers.
Very well, I see
tick
that,
box
yes.
answers. What we would submit is that these are the 6 factors which are essential for the decision maker to then form the view cumulatively in light of the answers to all those 6 factors, whether as a matter of fact the material before the decision maker gives rise to serious reasons for considering that he was a knowing accomplice in the war crimes or crimes against humanity committed by that organisation.
While you've been addressing some of these points, I've been looking at page 532, which is the decision letter, and the critical paragraphs, I think, are 31 to 36,
My Lord, yes.
especially 34. And perhaps you might like to take us through that. Is this a convenient point to do that? Because we can see the way it was approached by the decision taker.
My Lord, yes. Well, my Lord, that was what I was going to do, and I will do that now, I will need to, not lose sight of that, just take your Lordship briefly through the legislative framework. But I'll do the decision letter first and then come back to that.
All right, thank you very much.
As your Lordship rightly pointed out, the decision letter starts at page 528 of the full volume. And just in relation to the question of appeal, your Lordship will see the letter at 527, which is the determination of the asylum claim, where it is recorded that the asylum claim has been refused for the reasons given in the enclosed reasons for refusal letter. And in the last paragraph, this decision is not an appealable decision under section 82 of the Nationality, Immigration and Asylum Act. We then have the letter at 528, setting out under heading of basis of claim at 529 in detail his evidence, and then at 29 on 531, the conclusion that he has given credible account of his service with the intelligence wing of the LTTE, and further photographic evidence submitted with your claim shows him in uniform over a number of years. It's considered that this evidence supports your claim to joining the LTTE as a child soldier, supports your claim as having acted as a bodyguard to Potu Aman at meetings with Colonel Karuna. And they've then set out some of the evidence that relates to the LTTE and its activities in paragraph 30. And we then see in paragraph 31 that in light of that country objective evidence, it's considered that the LTTE and the intelligence wing of the LTTE have, over an extended period of time, including between 2000 and 2006, when you were both an adult and an active member of the LTTE, been responsible for a wide range of war crimes and crimes against humanity. And that, and I will take your Lordships to that, of course, was something which was accepted by the Court of Appeal. We then have consideration of the kind of factors that flow into whether he was a knowing accomplice. In the next paragraphs, we have the finding that from the evidence produced by you, you have shown that you were a long-term voluntary member of the LTTE who served in the intelligence wing of the LTTE in a variety of roles, and the fact that you were appointed to be a bodyguard for Potu Aman, the head of the intelligence wing, provides evidence of how highly trusted you were within the LTTE. Then in 33 it sets out that, again going to the voluntariness of the membership, it's considered that if you were acting against your will as a member of the LTTE, you would have had opportunities to leave the organisation during the period between 2000 and 2006, i.e. during his majority, when he was over 18. However, it's considered that you continued to operate within the LTTE and even gained promotion. This shows you were a voluntary member of the LTTE. In this regard, the case of Gurung has been considered, in which it was determined that voluntary membership of an extremist group could be presumed to amount to personal and knowing participation, or at least acquiescence amounting to complicity in the crimes in question. Accordingly, it's concluded that your own evidence shows voluntary membership and command responsibility within an organisation that has been responsible for widespread and systematic war crimes and crimes against humanity. And the evidence you have provided is considered that there are serious reasons for considering that you were aware of and fully understood the methods employed by the LTTE. It's therefore considered that you have been complicit in war crimes and crimes against humanity. And
So,
of course,
if I can just stop you there, I'm sorry. I'm just looking at your list of 6 factors, and 1, 2, 3 and 4 are quite straightforward, I think. That's nature of the organisation, method of recruitment, opportunity to leave. In fact, up to 5 are straightforward.
My Lord, yes.
But it's 6 that troubles me a moment, is knowledge of the organisation's war crimes or atrocities. Now, is it the last sentence of 35?
My Lord, yes, it's essentially the last sentence of 35, where the Secretary of State concludes on the evidence he has seen that he was aware of and fully understood the methods employed by the LTTE.
I mean, I'm sorry, just before you even get to, do you accept this is not a Category 1 case?
So
You gave us 2 categories, and as I understand it, the list of 6 only applies where it's not a Category 1 case.
Well, my Lord, I accept that it wasn't put as a case, that the Secretary of State's decision isn't expressed as one that relates to organisation of a limited brutal purpose. I couch my answer in those terms because, as your Lordships may have seen, in the Canadian cases, on a number of occasions, the Canadian courts have concluded that the LTTE was an organisation of a limited brutal purpose, or that the Refugee Determination Authority in Canada had not made a public law error in concluding that it was a limited brutal purpose organisation. And therefore, while the Secretary of State's case wasn't put on that basis, in our respectful submission, it certainly could have been. And the LTTE is in that bracket of organisations where one could reasonably conclude that it is a limited brutal, or was a limited brutal purpose organisation.
But you accept that the approach taken, so far as we can see at 532 and 533, is based on the assumption that it's not a Category 1 case.
My Lord, yes, the approach taken reflects the six-factor approach. And in one sense, of course, the six-factor approach ultimately, depending on the answer to question 1, or factor 1, leads to the limited brutal purpose. In a sense, the first category is a culmination of, or is a subcategory of 2, where the nature of the organisation is such that it just has effectively no other purpose, or that its principal purpose is, as I think the IAT put it, the predominant purpose is, as the IAT put it in Gurung, or the Canadian jurisprudence calls it, the principal purpose is terrorist, or involves the commission of war crimes and crimes against humanity. And of course, even though I accept that the case was considered on the basis and by reference to the factors which I've sought to set out, the answer to question 1, i.e. the nature of the organisation, has to be, the approach to the second question has to be informed by the fact that the answer to question 1, i.e. the nature of the organisation, is such that the organisation itself is one which could reasonably be classified as a limited brutal purpose organisation. And therefore, if one looks at it as a scale, is very much at that close to that extreme end of the scale, rather than being at the other end of the scale, which again one sees in some of the Canadian case law, where one talks about the military forces of South American countries, where a member of the Navy was excluded under Article 1FA. And there, of course, the questions are very different and potentially more nuanced. But here we have an organisation which, on the evidence, is close to, if not and in some cases capable of being categorised as a limited brutal purpose organisation.
I just wonder what one takes from the word organisation, because as I understand it, the LTTE is quite a wide, or was at least quite a wide-ranging body with an air force and a navy and so on, and there's a flavour of some regular military activities and possibly other activities as well. So it's not in the broadest view of it, it's not devoted entirely to the commission of atrocities, I would have thought. But are you suggesting then that we should focus on the intelligence division, which you say is more targeted on that kind of activity, or do we take the LTTE across the board, or what?
My Lord, again, the decision letter and the report focuses on the intelligence division, but Your Lordship, of course there is the reference to the LTE broadly and the fact that it had a navy and an air force and the like. But in our respectful submission, and that's why I make that submission now, is, for example, one of the aspects of country information is that they, for a period, routinely forced families to surrender one of their children to serve in the LTTE. Whether that is in a combat unit or not, that is contrary to the Geneva Conventions on the Law of War. That is, if it's done routinely, is a grave breach of those and amounts potentially to a war crime under the Geneva Conventions. One only needs to look at Article, I think it's 147 of the Geneva Convention. And now, in our respectful submission, one can't, even if one were to look, and the decision letter deliberately looked at it through both glasses, or in both, by reference to both the umbrella organisation and its subunit, but one can't ignore the fact that there were routine aspects even of the, if one wants to call it that, normal combat activities of the LTTE, which involved routinely attacks against civilians and the recruitment of child soldiers, both of which are potentially capable of amounting to war crimes. And therefore, we have the examples in Canada where the LTTE has been found to be such an organisation as the larger organisation, partly also pointing to the fact that the political wing of the LTTE, that which participated in the legitimate political process, insofar as that was possible, was hived off into a different organisation in the mid-80s, as I understand it. As a result, the courts in Canada certainly have felt able to describe it, the LTT as such, as a limited brutal purpose organisation. But the decision letter focuses, in addition, on the fact that he was particularly concerned with and engaged with the intelligence division. So we're not here talking about an ordinary foot soldier who's swept up in a civil war.
I do find this concept of a limited brutal purpose very difficult, because we're not concerned in this case at all with international law as to whether the difference between an armed conflict and a war, I think, are we at all. So if you have a large-scale insurrection, the purpose of which is to achieve self-determination and independence for the part of a sovereign state, and they are prepared to bomb and kill as many as they can of the military forces against whom they're fighting, but they avoid war crimes. You say that isn't in either of your categories, is it? What would you say about that?
My lord, that kind of organisation wouldn't be in either category, because it wouldn't be principally or primarily or predominantly engaged in committing war crimes. It would be seeking to effect self-determination.
But there must have been a very, very large number of Tamils, including those who were recruited as children, who were doing just that in the northern part of the island, weren't they, and didn't have the remotest idea of what was going on, except that they thought they were fighting for independence.
My lord, yes, which is why even in relation to the limited brutal purpose organisation, and I fully appreciate your lordship's difficulty with the concept, is that needs to be knowing. The question of knowledge is still relevant, but what, for example, UNHCR suggests is that when you have such an organisation, it creates a rebuttable presumption, which then accounts for the fact that in these kind of scenarios, evidentially, it is extremely difficult to pin, as the courts after the Second World War recognised, it's extremely difficult to pin one individual to a particular atrocity, but the international community has to protect itself against these war crimes and crimes against humanity, and therefore what is created is a rebuttable presumption where it enables the individual to say, well, I didn't know anything about this.
Is there a distinction then between the aims and the methods of achieving the aim? The aim may indeed be, leaving aside method for the moment, to achieve independence.
Yes, my lord.
If the methods used are regular combat and so on and so forth, then you don't get to the categories.
My lord, yes. And again, the scenarios we've seen in relation to regular army exclusions in the Canadian case law is they're usually focused on an identified atrocity.
Well, you mentioned the Peruvian Navy one. I mean, that was a particular atrocity when they went and put down a prison riot with extreme violence, and there was quite detailed evidence about that particular incident. I mean, that was very, very different from what we're concerned with here.
Yes, it is. But it also, that case, of course, focused on the fact that that was, in a sense, an organisation as an organisation, which every state has a legitimate right to have set up and run, which is not predominantly set up to commit atrocities, or doesn't, as its predominant means of achieving its objective, commit atrocities. Defending the borders against insurrection and the like, as such, isn't in that category. But that's, and I think the question my Lord Hope put to me, that is, of course, right, where the method is one which puts you in the category where you primarily or predominantly deploy terrorist methods or criminal methods to achieve your aim. And that is, of course, what the evidence points to in relation to the LTTE, suicide bombers and the like, which has led to its listing as a terrorist organisations by the EU and others. It is the choice of methods which then makes you an organisation which falls within that category.
And then, as far as the individual is concerned, it's awareness of that choice.
My Lord, yes.
So if you're, as it were, the innocent recruited child or whoever he is who joins the organisation, is persuaded that independence is what it's fighting for, and has no knowledge or no reason to suspect that it was carrying out these atrocities, then the issue doesn't arise. But as I understand paragraph 35, it's saying that isn't this case.
No, my Lord.
Because of the background which is set out in the earlier paragraph.
My Lord, yes. And it isn't this case because, amongst other things, there is no evidence here that he... one is there is no evidence that he was coerced and therefore that he just fought for that reason. His own evidence is that since 2002 he's been thinking about leaving, but he went on and obtained promotion. And it is that in light of the role he fulfilled, or the various roles he fulfilled, that there are serious reasons for considering that he would have been aware and would have fully understood the methods deployed by the LTTE in fighting for its aims. And that it was that knowledge which brought him, or which brought the Secretary of State to conclude that looking at all the factors in the round and all the evidence in the round, there were serious reasons for considering that he was a knowing accomplice to war crimes and crimes against humanity.
As I understand, you say this is not a limited purpose organisation, and you say, as I understand, this is an organisation which is prepared to carry out combat with armed forces, but is also prepared to go further than that and to commit crimes against attacks on civilians and so on. And therefore, it takes in. I actually find it very difficult to imagine that there's any organisation which says, I'm only actually going to do attacks on civilians. I mean, I find that very odd. I mean, I can see why one would say, I'll go further than attacking the military, but why should I? I find the idea of one whose only purpose is to attack civilians or something slightly bizarre. I think I'm finding this idea of limited purpose slightly odd, actually.
My Lord, yes, and to some extent, of course, that again that's the danger with using that kind of terminology, because, of course, as one sees from the UNHCR documentation, post 9/11, of course, in Al Qaeda, one might have an organisation which it may be capable of saying is in no way or form a legitimate kind of war opponent engaging military forces, even though that may be in doubt, but is primarily set up for the purposes of committing atrocities. But we're not here saying that the LTT is in that category, and the decision letter makes clear that it was, in a sense, by reference to the 6 factors I've identified, that taking those in the round, we would submit that the Secretary of State was entitled to come to the conclusion that there were serious reasons for considering that he is responsible, or that he committed crimes against humanity, and that therefore he fell to be excluded from the benefit of the Refugee Convention. And again, like your Lordships pointed out, the emphasis, of course, has to be on the activities of the organisation and then his role in it. And that's where the large part of the evidence in the War Crimes Report goes to the activities of the organisation, which found the view that it is an organisation which has been responsible for war crimes and crimes against humanity, and which therefore raises a question about exclusion, and then on the basis of his own evidence led the Secretary of State to conclude that it was right to exclude him because there were serious reasons for considering that he was capable of being held responsible for those war crimes.
My impression is that the war crimes element of the method of combat, if I can describe it as that, involved an element of planning. I mean, there are some instances where war crimes are alleged which occur just off the cuff. People, soldiers, lose control of themselves and do appalling things on the spur of the moment, and it's unplanned and unorganized. But in this case, the impression given by the report is that there is a lot of organization arranging for people to be infiltrated into civilian areas so that they can carry out these activities. And therefore it's not a sort of ad hoc, off-the-cuff emotional reaction. It's a deliberate course of conducting the campaign.
It's a specific aspect, deliberate aspect, of the organisation's methods of achieving its aim is to use criminal means, such as the commission of war crimes, and it isn't, as your Lordship rightly said, it isn't a one-off. And of course it is part of the definition of war crimes and crimes against humanity in most of the statutes that there is either a system or a plan as part of the definition of war crime. But that here is, we would submit, plainly a case where it was part of the LTT's design to use methods, terrorist methods and criminal methods to achieve the aim it had set out to achieve. And that's why we submit the focus has to be on the nature and the activities of the organisation rather than on necessarily its stated aim.
Now, I fear I took you out of order a bit by asking you to address us on the letter. You were going to go to the statute, I think.
My Lord, I just wanted to take your Lordship briefly through the different the legislative framework, if I may, just so we have that in mind. And the first, of course, is Article 1F, which your Lordships have in Authorities Volume 3 at tab 31. Where your Lordships will see at page 12 at page 16, my Lord, sorry, Article 1A, the now very familiar definition of refugee in Article 1A2, and then over the page, at page 18, we have what 1F, the provisions of this convention shall not apply, and there we have the mandatory nature of the provision to any person with respect to whom there are serious reasons for considering, and we say that's important, that is the test that's laid down, that he has committed, and we leave out a crime against peace, a war crime or a crime against humanity, as defined in the international instruments, in the plural, drawn up to make provision in respect of such crimes. And we say it's important, one, as I said, that there is the test serious reasons for considering, and not, because if they didn't have a particular meaning, they are in a sense OTOs. Because he could have said, provision of this convention shall not apply to any person who has committed. And secondly, that the reference is to international instruments in the plural, drawn up to make provisions in respect of such crimes, and not necessarily and not to such crimes, for example, contrary to international criminal law. And one of the reasons we say that is important is because it pulls together the whole array of instruments that are available defining such crimes, whether in statutes of various international tribunals or courts or elsewhere, on which reliance can be placed, and they are all relevant rather than only one being relevant. So
It doesn't anchor itself to the state of play at the date when the convention was entered into.
Present and future.
my Lord, yes, it is present and future, and it left open that future instruments might lead to a development, or might classify other crimes as such crimes, and therefore left it open that there would be a development in international law. In particular, the drafters perceived that the International Law Commission would come up with a draft code on relevant crimes, which has now been published in its latest draft in 1990. But they knew that was in process, and therefore didn't want to close the door on that being encompassed within this process.
I suppose the word "he" is important too, isn't it? Because it is directed precisely against the individual. It doesn't say a group of which he is a member or something of that kind. So you've got to point the finger directly at the individual to make sure that it works.
Which is why we come to, rightly, and that's where the Canadian case law draws its force from, and Gurung draws its force from, why we come to the concept of joint criminal enterprise as developed in international criminal law, as to the, starting with the IMT, the International Military Tribunal, which of course did provide for attribution of responsibility, amongst other things, by reference to membership of particular organisations, through to the case law in Tadic and Krasnich and others, as to the reach of joint criminal enterprise. My Lords, that's Article 1F. We then come to the other instrument which we say is highly relevant, which is the Qualification Directive, which your Lordships have at Volume 10 of the Authorities, at tab 73.
Sorry. Oh, yes, sorry.
Volume 10, my Lord, tab 73. I've now done what I pressed the button, sorry. And your Lordships will see there, Council Directive 2004-83 on minimum standards for the qualification and status of third country nationals as refugees. And we see in the preamble, paragraphs 2 and 3, the reference always back to the Geneva Convention, that is the Refugee Convention. We then have in paragraph 6, main objective of this directive is to ensure that member states apply common criteria for the identification of persons genuinely in need of international protection, and on the other hand to ensure that a minimum level of benefits is available to these persons in all member states. And it's important that it's common criteria for the identification and minimum standards as to their benefits. In paragraph 8, there's then provided for a power to introduce or maintain more favourable provisions for third country nationals or stateless persons who request international protection, where such a request is understood to be on grounds that he is either a refugee or a person who otherwise needs international protection. And that, of course, allows for, in a sense, Article 3 protection, which falls outside either concepts defined by the directive, namely refugee status or humanitarian protection status. There's then, at paragraph 16, the minimum standard for the definition and content of refugee status should be laid down to guide competent national bodies in the application of the Geneva Convention. and it's 17, it's necessary to introduce common criteria for recognising applicants within the meaning of Article 1 of the Geneva Convention. And we then have, over the page, Article 2, C. Your Lordships will find the definition of a refugee. And again, the language of the first 6 lines is familiar from Article 1A of the Geneva Convention, Refugee Convention, but it's important to note that and to whom Article 12 does not apply. And that takes us to Article 12. And 12.2, a third country national or a stateless person is excluded, not maybe, but is excluded from being a refugee where there are serious reasons for considering that he or she has committed a crime against peace, a war crime, or crimes against humanity as defined in the international instruments drawn up to make provision in respect of such crimes. So again, very much familiar wording, but importantly, we submit 12.3 adds, paragraph 2 applies to persons who instigate or otherwise participate in the commission of the crimes or acts mentioned therein. And we say that's important because it recognises the broad reach of the exclusion and confirms, through the means of legislation adopted by 27 member states of the European Community, the broad reach of the exclusion and the reference to, my Lord Hope put to me, the he commits in 1F A and in 12.2a of the directive.
So is it really achieving what you mentioned earlier? One sees through the Canadian cases, or the case law generally, the idea of participation, joint criminal participation.
My Lord, yes.
That's the point, really.
My Lord, yes. But it makes express reference to it, and we will see that, of course, is also one of the important differences between the ICTY statute and the ICC statute, with the ICC statute making express reference to it, where the ICTY statute doesn't, and the tribunal has had to kind of read the concept of joint criminal enterprise into the word commits in Article 7 of that statute. That directive has been implemented, if I can call it that, in domestic law via the refugee, etc. qualification regulations, which your Lordships have at Volume 1, Tab 6. And your Lordships will see there that this was our regulations adopted under Section 2 of the European Communities Act, and define refugee in Regulation 2, the 6th entry. Refugee means a person who falls within Article 1A of the Geneva Convention and to whom Regulation 7 does not apply.
Sorry, where's that?
So this is Regulation 2, my Lord, interpretation. It's adopted a similar approach to the directive, which deals with the definition of refugee in the interpretation section.
Yeah.
And then Regulation 7.1, a person is not a refugee if he falls within the scope of Article 1D, 1E or 1F of the Geneva Convention. And then in 7.3, Article 1FA and 1FB of the Geneva Convention shall apply to a person who instigates or otherwise participates in the commission of the crimes or acts specified in those provisions. And again, we find that the language of the directive replicated. And just as another point, in the explanatory note, it's clear that in the first sentence that this was in part to implement Directive 2004/83. And finally, then we have the immigration rules, which are in tab 4 of the same volume, which do not, and insofar as there is a dispute between the parties about the status of the Convention in domestic law and the status of the partial incorporation through the 1993 Act, it does not provide a definition of who is a refugee, but in para 334 provides what domestic law status he will get, namely asylum, if he is a refugee. This is subparagraph Roman 2, as defined in Regulation 2 of the 2006 regulations.
Which is the rule which says that he doesn't even get humanitarian aid and so forth?
My Lord, the exclusion from humanitarian protection, my Lord,
Yeah.
is at 339D over the page,
Yeah.
where it says a person is excluded from a grant of humanitarian protection under 339C4 when the Secretary of State is satisfied that, 1, there are serious reasons for considering that he has committed crime against peace, a war crime, a crime against humanity, or any other serious crime, or instigated or otherwise participated in such crimes. And your Lordship ought to be aware that that reflects the provision in the directive, which of course, apart from dealing with refugee status, also deals with subsidiary protection in Article 17 of that directive at volume 10, tab 73, where effectively the language of Article 12 has been replicated. So this is Article 17.1. This is volume 10, tab 73. This is back to the directive, just to put the refusal of subsidiary or humanitarian protection in context.
So the subsidiary is the equivalent of humanitarian.
Well, yes. Under the English concept of humanitarian protection is the equivalent to subsidiary protection under the directive.
Article 17.
17.1a and 2. And your Lordship will see that replicates the language we looked at in Article 12.
But I mean, there is still the ECHR Article 2.3 inhibition on return.
Yes, my Lord, there is, and of course there is that and other reasons why outside the immigration rules it is open to the Secretary of State, and in some contexts he may be required to, for example by Article 3, to grant leave outside the rules, even though
I mean, has that issue ever been raised in our case? I mean, I thought it had, but I'm not...
My Lord, the issue...
Well, the issue as to whether in any event he could be returned, having regard to the Article 2.3.
My Lord, certainly not at the Court of Appeal stage or at this stage, my Lord, no.
He was refused.
He was refused humanitarian protection in the decision letter, and which your Lordships have at page 528 of the...
Is it 527? 527 is the refusal, I think.
I mean, he was held not to have established any well-founded fear of persecution.
Where's that?
38, paragraph 38, final consideration.
So, my Lord, where are you?
In the refusal letter.
In the refusal letter, it says
Oh, I see, yes.
both humanitarian protection and...
Witness,
I don't think it is. I mean, humanitarian protection is not the same as protection against
No, my Lord.
return, but I mean, there is an express claim under paragraph 4 of the decision letter on the grounds that if he's returned, he'd face a real risk of suffering serious
harm, etc.
If you were removed. But, my Lord, because the Secretary of State in paragraph 39 has exercised his discretion in favour of granting leave, of course the threat of removal was never present.
I see.
As I understand the reference in the second last sentence in 38, it's a refusal under paragraph 339F, which we see refers not to 339D, but to 339C. So it's a different avenue of refusal. It's simply that he didn't meet the requirements of 339C, and that led to 339F, because the criteria were not met.
My Lord,
am
well,
I right in
if one
understanding
looks
it
at
that way?
339F, it says where the criteria set out in 339C is not met. If we
Yes.
then look at 339C,
Yes.
Romans 4, he is not excluded from a grant of humanitarian protection, which then takes us to 339D,
Ah,
which is where he is excluded.
I see. Sorry, I beg
So,
your
my
pardon.
Lord,
So one
it's-
reads the two together. And
One reads
he's
the two
trapped by-
together, but the refusal is under 339F because
Yes.
that is the instruction in a sense as to the decision that has
Right,
to be
I
reached.
follow. Thank you very much.
But I mean, sorry, are you accepting he may well be entitled not to be returned because of Articles 2 and 3 of the ECHR? I'm not suggesting that that means that this is academic. Of course it's not. It's, there are very real benefits from gaining immunity, gaining refugee status.
My Lord, that was canvassed in correspondence. I would need to take some instructions as to whether we accept now that that is the position. But of course, in relation to receive either refugee status or humanitarian protection status under the directive, that can only happen if he's not excluded.
Yes, I follow that absolutely.
And in that sense, it is, we would say, academic, because there's no threat of him being removed, because there's no suggestion that his current renewable discretionary 6-month leave will not be renewed.
So, we're to work on the basis that he'll go on getting 6 months' leave, sorry.
That certainly is the position at the moment. That leave is reviewed, and of course the situation in Sri Lanka is one that is, especially now, very much in flux, and therefore how long it will be renewed is not something I can say. But it's at the moment he has, since that decision letter, he has had sequential periods of 6-month leave. And there is no current risk or threat of him being removed to Sri Lanka.
When it held that he didn't qualify under 336, in other words, he had no right to asylum at all, as I understand.
My Lord, yes, the point I was seeking to make by reference to, he had no right to asylum, but the reason he had no right to asylum was because he was not a refugee under the regulations.
Because?
Because he was excluded from the benefit.
Only because he was excluded.
Well, that's certainly the decision letter. Your Lordships will see. The decision letter goes on, is expressed. Paragraphs 1 to 37 effectively deal with the concept of exclusion. The letter itself does say it has been concluded that you have not established a well-founded fear of persecution,
Yes,
and
exactly.
that you do not qualify.
That looks like a plain vanilla refusal.
Well, it is, my Lord, yes. But it is... but it has been done, of course, by reference... It has been done by reference to the reasons, so on the basis that he... The whole import of the letter is that he is excluded and therefore is not entitled... my Lord, can I just turn up 336? Because, of course, just as we had with 336F, the refusal under 336 is capable of covering both.
No, I see that. I do see
Of
that.
covering both.
It's just it's about the no... It's
The letter is expressed as not recognising even what my Lord Brown puts to me, namely that there is a well-founded fear of persecution. Yes, ma'am. I have to accept that. But of course that is an assessment which is one that is time sensitive, and I'm not in a position at the moment to say whether it is now accepted that he is at risk, contrary to Article 3 or not.
I mean, it would have been surely difficult to suggest that, wouldn't it, back in September '07, wouldn't it?
Well,
When the letter was written, I mean.
my Lord, it may well be, but as I indicated before, that there was never a threat of him being removed, and the conclusion had firmly been reached that he was excluded and therefore not entitled to either status. The next point of this journey, if I can call it that, I wanted to take your Lordship to the Court of Appeal. I'm very conscious of the time, but I will try and make as much headway as I can. And the Court of Appeal, of course, is in the core volume at page 3. And your Lordships will see, in a sense, starting at paragraph 24, going through to paragraph 29, the court there setting out the grounds of appeal, and setting out in paragraph 26 3 submissions made by Mr. Dillon on behalf of the Secretary of State. One, there was evidence in the material before the court that during the period the claimant was an adult member of the LTTE. The LTTE was responsible for widespread acts amounting to war crimes or crimes against humanity. Despite the fact that a ceasefire was supposedly in place for most of that time, Intelligence Division was an elite, feared and highly secretive branch of the organisation, believed to be involved, amongst other things, in political assassinations and the use of torture to extract information. There was also material to suggest that its activities included guiding suicide bombers to their targets and forming hit squads to target civilians. And two, there is a significant difference between the defendant having serious reasons for considering that a person has committed a war crime, crime against humanity, and an international criminal tribunal having sufficient evidence to prosecute that person. The person may fall within the exclusion provided by 1FA, although further investigation and evidence gathering may be needed before that person could be charged with a particular offence. And we would say it's important that they say charged rather than convicted, especially in light of the question posed by my Lord Brown earlier. In paragraph 27, the Court of Appeal then accepts the first two of those submissions. I was initially troubled by the lack of any attempt to identify more precisely the activities of the LTTE, which were said to amount to war crimes and crimes against humanity, for which the defendant considered the claimant to be criminally liable. During the oral argument, Mr. Dillon persuaded me that his first submission was correct, but I think that it would have been preferable if the decision letter had identified instances of the relevant types of crimes. Not least, that is relevant when examining the grounds for considering the claimant to be criminally responsible, but they do accept the war crimes, crimes against humanity committed by the LTTE and the evidence in relation to the Intelligence Division. And then second, he also accepted, the Court of Appeal also accepted Mr. Dillon's second submission, which was not seriously challenged. That is the difference in the standard of proof, if one can call it that. And that, in 29, then leaves the critical question whether the defendant's reasoning for considering the claimant to be guilty of international criminal law of war crimes, crimes against humanity, was sound. And that was, in a sense, the only issue that was before their lordships. We then have, through paragraph 30 through to 52, we have a consideration of the international instruments, starting with the ICTY statute and the ICC statute, and there in paragraph 33, the reference to joint criminal enterprise in Tadic, and in paragraph 45, the reference to the then recent decision in Kreisnick in relation to joint criminal enterprise.
Sorry, what have you just said?
Sorry, in paragraph 45, the reference to the then very recent case of Krasnich. Your Lordship may recall the procedural history was the argument had been completed, and the clerk for Lord Justice Toulson then wrote to the parties and pointed them to, amongst other things, this case, and asked them to comment on it, without, in a sense, putting Gurung in issue, but asking them to comment on Krasnich, which is what the parties did. We then have at 52 a recitation.
Have we got were there further written submissions?
There were further written submissions.
And we got those,
My
have we?
Lord, yes, we do. The submission on behalf of the Secretary of State are at page 43, my Lord, and the written submissions on behalf of the respondent, now respondent, are at page 49 through to page 52.
Page what?
49 through to 52.
These were directed particularly to that case.
These were, your Lordship will see at page 43, they refer to the email, which your Lordship also have at page 539, and the invitation to make further submissions in relation to those two cases. And your Lordship will see the form of the email. That conveyed that invitation to counsel. And of course, the submissions of the Secretary of State at page 43 then, in addition, raised the judgment in April 2009 of the Court of Appeal in KJ, Sri Lanka. And your Lordship will see the Secretary of State dealing with Krasnich at paragraphs 2 through to 7, pages 44 to 45, and the respondent at paragraph 2 and 3, pages 49 and 50.
Yes.
Going back to the Court of Appeal, then we have at paragraph 53 reference to some Canadian cases, principally because the IAT drew support from them in Gurung, namely Ramirez and contrasting it in 56 with Tadic and Krasnich, and then Moreno in 57 and Sivakumar in 58. And then we have a consideration setting out the domestic cases, i.e. the English cases, at paragraphs 59 through to 92, starting with Gurung, and concluding effectively with MH and KJ, which were then the most recent, I think still are, were the most recent decisions. Then we come to 93, where the court records the challenge that was put before the Court of Appeal, or was not put before the Court of Appeal, as Ms. Jagaraja did not on the surface challenge the guidance given by the IIT in Gurung, but she relied on subsequent decisions of the AIT in cases of members of the LTT in support of her arguments summarised in paragraph 24 above, particularly as to the nature of the LTTE and what inferences may properly be drawn from the claimant's involvement in it. To those authorities may be added the observations of Stanley Branton in KJ at paragraph 38. However, in order to deal satisfactorily with the arguments as they were developed, it is necessary to re-examine the underlying principles governing liability for war crimes and crimes against humanity within the meaning of Article 1FA, which for present purposes I will refer to as international crimes. And then 95, expressing agreement with Gurung in relation to the fact that the international instruments and the jurisprudence of international criminal tribunals which have had to interpret and apply them must be the principal source of reference for domestic courts. However, I would not approve the further guidance given by the IAT in Gurung for determining whether there are serious reasons for considering that a person is guilty of such crime in a number of respects and for a number of reasons. And then sets out in 97, second sentence, moreover, with all respect to the tribunal, its approach to liability for international crimes in the context of an organisation which uses criminal methods on a regular but not exclusive basis is, to my mind, less structured, less clear, and as a result potentially wider than it is to be found in the ICC statute or other international instruments to which we have been referred, or in the ICTY case law. And then in considers part of the facts, and then over the page at 104 identifies the principles of joint criminal enterprise as understood by the Court of Appeal. According to that jurisprudence, i.e. the jurisprudence of the ICTY, in order for there to be joint criminal liability, there first has to be a common design which amounts to or involves the commission of a crime provided for in statute. Actus reus requirement for criminal liability is that the defendant must have participated in the furtherance of the joint criminal purpose in a way that made a significant contribution to the crime's commission, and that participation must have been with the intention of furthering the perpetration of one of the crimes provided for in the statute. It then disapproves Gurung and the UNHCR in relation to its approach to a rebuttable presumption in relation to asylum seekers belonging to extremist international terrorist groups. And then in (107), a person who becomes an active member of an organisation devoted exclusively to the perpetration of criminal acts may be regarded as a person who has conspired with others to commit such acts, will be criminally responsible for any act performed in pursuance of the conspiracy. I use the words active member deliberately, as without any other conspiracy there may be questions about the scope of the conspiracy entered into by persons concerned, whether there was the requisite proximity between what he agreed and the crimes or crimes in question. The Secretary of State, in considering an application for asylum and the effect of Article 1F, is concerned only with whether there are serious reasons for considering that the applicant has committed an international crime. And in the case of an active member of an organisation dedicated entirely to terrorist activity, that is unlikely to present any problem. However, Lord Justice Stanley Burnton said, it is another matter if an organisation pursues its political ends in part by acts of terrorism and in part by other means. Joining such an organisation may not involve conspiring to commit criminal acts and in practice doing anything that contributes significantly to the commission of criminal acts.
You accept that paragraph?
My Lord, I don't accept that paragraph in its totality and read in the context of the whole of this criticism, because what it leads to is we say, too narrow an approach to the concept in question under 1FA, because the Court of Appeal ignores, we submit, what is our first question and the fluidity of the answer to that question, namely the degree to which an organisation uses those criminal means in order to commit, in order to achieve its aim, and it focuses on the furtherance of that crime rather than the common purpose of that organisation, which we respectfully submit is what the focus should be on. And as a result, and of course this paragraph looks at the looks at the concepts of conspiracy rather than the concept of joint criminal enterprise, which all the case law in the international courts makes clear is a different concept.
I'm still having a lot of difficulty grappling quite with where you are. Knowing accomplice is the phrase you've used for categories 1 and 2.
My Lord, yes.
Under category 1, there's a rebuttable presumption that he's a knowing accomplice, and then the six questions you ask yourself in deciding, in respect of not such a body, whether he's a knowing accomplice. Is that the same as being complicit? I mean, are those words interchangeable? And likewise, are they interchangeable with the concept of participation in these various crimes? Are these all interchangeable expressions, or are they different?
My Lord, as I understand it, they are not interchangeable positions. Because if one looks at, for example, because as I understand it, the concept of joint criminal enterprise is different.
Well, I haven't put that into the frame yet. I want first to start with these concepts which you have been using of knowing accomplice, complicity and participation. Are they all interchangeable? Whether they all amount to the same as joint enterprise liability or joint criminal enterprise we'll come to later.
My Lord, insofar as they all involve the element of knowing and voluntary, yes, they are.
But you say that's enough, knowing and voluntary. You say if you're a knowing accomplice, that's it. You're complicit, you participate, you're on the wrong side of the
My Lord, yes.
one FA, yeah?
My Lord, yes.
It takes you, obviously, beyond mere membership, which is the voluntary part of that.
My Lord, it's the knowing, the knowing aspect of it, and in a sense, and the knowing aspect of it, and the sharing with that knowledge, and the continued and the voluntary continued membership, showing that you share that common purpose.
But I'm sorry, I thought, I mean, if that's all it is, you don't need all 6 of the touchstones, or not the touchstones, that's the factors.
Well, my Lord,
I mean, it's all the difference. I mean, you say you're a foot soldier in the uniformed wing of the LTTE.
my Lord, yes.
I mean, you're furthering the interests of the LTTE as a body, and just assume that you know perfectly well, because I thought all you've got to do is read the local newspapers to discover that actually there are aspects of the LTTE who are involved in atrocities against civilians and all that sort of thing. They know there are suicide bombers amongst the ranks and so forth. And you're a volunteer, you stay as a, however you were recruited, you know, there you are, you stay a voluntary member of the LTTE. Well, now, is that good enough for your purposes? Is that a knowing accomplice? Is that complicity?
Well, my Lord, we would certainly submit that it is capable of being so, yes.
Sorry, capable depending on what?
My Lord, the purpose of the 6 questions, as I've sought to identify them, is to enable a decision maker to look at the material in the round and have guidance as to which factors to look at to see whether ultimately it leads him or her to conclude that there are serious reasons for considering that he is so responsible or not. And that's not a decision in the sense that is a purely factual decision, which, of course, it is capable of reaching different conclusions on.
I mean, it involves more than just deciding A, if he's voluntarily a member, and B, that whether he knows that some part of this organisation are committing atrocities. Because otherwise, what's the point of C, his position and the rank in the organisation? You're there touching on some question of, so to speak, responsibility for it.
My Lord, yes, and if your Lordship's example were that he is and has always remained no more than
I put him as a foot soldier.
A foot soldier, a private, then one would have thought that he's unlikely to be excluded under the convention. But if, knowing what he's done, he stays with the LTTE and achieves promotion, as this individual has, then that may be the conclusion reached by the decision maker may be a different one. And that's, again, where we come to the kind of question that the Court of Appeal had to ask itself, was, on the facts of this case, was the decision that the Secretary of State reached one that was unreasonable?
But to decide that he is a knowing accomplice, stroke, is complicit, stroke, has participated, it doesn't need to be joint enterprise liability or aiding and abetting.
My Lord, we certainly would submit that it doesn't need aiding and abetting, and what I will seek to draw out of the international instruments I'm going to take your lordships to and the case law is that this kind of conduct is capable of being covered by joint criminal enterprise as interpreted by those tribunals which were responsible for interpreting the Nuremberg, the chart of the Nuremberg Tribunal, and we would submit the ICTY jurisprudence.
I wonder whether it's helpful to just look on to paragraphs 115 and 119, because having introduced the subject in the way we've been looking at, we see how the Court of Appeal draws this to a conclusion, and the starting point is identified in 115, but the really important paragraph, I thought, was 119.
My Lord, yes, and that's what I was going to come to.
And one can see, reading that, a difference between what's put out there and what you've just been saying.
My Lord, yes. And that's what we take issue with, especially in paragraph 119, 2 and 3, that the focus is one that is too narrow, even building on the jurisprudence of the ICTY, is too narrowed by requiring a significant contribution to the crimes commission rather than to the common purpose. Because one of the aspects of joint criminal enterprise as it comes out, both of the early jurisprudence of the tribunals after the Second World War and the ICTY, is that the conduct itself doesn't need to be criminal, it doesn't necessarily need to be directed at any particular identified crime, it needs to be in furtherance of the common purpose.
Supposing that somebody's been a foot soldier in an organisation which carries out attacks, and let's suppose he's been a foot soldier for 10 years in this organisation, and over that 10-year period, this organisation has carried out, let's say, 40 known attacks, of which 20 are against uniformed soldiers on the other side and so on, and 20 are, let's say, attacks on civilians.
Oh, yes.
In that situation, and that's all you knew about, that he had been a member of this organisation which had done these things, would that be enough to say that you're reasonable grounds?
Well, that may well not be enough to show that there are serious grounds for considering, because of course that's serious reasons for considering. That's the test. Not because it doesn't fall, but by reason of an absence of sufficient of information in order to make good that test, rather than by reason of any legal difficulty with potentially bringing the individual within 1FA if the evidence existed.
That wouldn't be enough. But supposing they'd done, say, 30 out of the 40 attacks have been against civilians, would that be enough? I mean, I just don't, or does one have always to say, well, there's got to be something that shows that he was, to do with that? I mean, I find this slightly...
Well, my lord, it has to... It has to be... there has to be knowledge. It has to be knowing participation in the common enterprise, as the law suggests. And therefore, of course, the number of atrocities or the number of crimes committed may well influence the question of whether there are serious reasons for considering that he would have known. And 30 out of 40 may well suggest, well, it's unreasonable to suspect that he wouldn't have known, because it's the proportion of atrocities is so high that it's difficult to conceive of him having been completely shielded from that. Whether that's sufficient to reach the test of serious reasons for considering on an appeal is one question, because of course the tribunal reaches a new decision, but may well be one that can't be overturned as being unreasonable if it comes to court by way of judicial review.
Don't you have to combine two things? So one to see what this foot soldier is doing, as well as what he has reason to expect. I mean, if he's, this is why maybe the element in your category is about the position in the organisation that the individual holds may be relevant. If he's simply a foot soldier, he's a private soldier looking after himself, that may be one thing. But if he's in command of, let's say, 45 people or whatever it is, or second in command of the unit, then one imagines that he does have some control over what is being done, or some powers of direction, organisation, and so on. And so you've got conduct there which can extend beyond what he himself actually touches or does with his own feet or hands or whatever. And then you look to see what he's got some reason to expect to follow from what he's doing. I'm putting these questions unashamedly based on Article 30 in the ICC rules, which you'll see at pages 16 and 17.
This is volume
of the appendix, which talks about the mental element, which I thought...
So this is at page...
It's 16 and 17 of the Court of Appeal's judgment.
Oh, right, sorry.
It's the mental element part which Article 30 is dealing with.
Yes.
And which I thought from earlier discussion you would accept as something that is relevant to what we're discussing.
Yes, my lord. So, I mean, that's one of the difficult... That's why we are suggesting, or why our submissions are based on the 6 factors, because it needs to take the activities of the organisation into account, and we say the Court of Appeal hasn't done that sufficiently, but it also needs to take the role of the individual within the organisation into account.
Yes.
But it is within the organisation and with reference to what tends to be described as the common purpose, rather than with relation to a particular criminal offence.
Yes. Well, my impression is that the Court of Appeal at paragraph 115 focused on the particular offence as the starting point, and it may be there are 2 points here. One is that they say there's a difference between war crimes and crimes against humanity, and you ought to know what it is you're dealing with. But the other point would be focusing on particular instances of each of these 2 categories. And I rather think you're saying, all right, you can, if you like, distinguish between war crimes and crimes against humanity generally, but it's too narrow to focus on an individual act.
Yes, my lord.
If you're dealing with this kind of individual, where you're really dealing with the participation in what the individual has reason to expect the group to get up to,
yes,
over which he has some element of control.
Well, look, that's certainly right, and that's what we say is reflected. So runs through the whole of the case law of the courts on joint criminal enterprise, starting with the original Allied Forces tribunals, which had to decide under the Nuremberg Statute as to who was and was not responsible for the crimes committed by the Nazi regime in Germany. And
but in ICC terms, I understand you're not relying on Article 28, responsibility of commanders or other superiors.
no, my lord.
You're putting it entirely on an individual basis.
Yes, my lord. But we're putting it on the basis which it's all reflected in also in the qualification directive set out in 25.3d. Sorry, it's 25.3c.
Yes.
And potentially D, for the purposes of facilitating the commission of such a crime, aids, abets, or otherwise assists in its commission or its attempted commission, including providing the means of its commission, and in any other way contributes to the commission or attempted commission of such a crime by a group of persons acting with a common purpose. Contribution shall be intentional and shall either be made with the aim of furthering the criminal activity or criminal purpose of the group, where such activity or purpose involves the commission of crime within the jurisdiction of the court, or be made in the knowledge of the intention of the group to commit the crime. It's those 2, which are of course not present as such in Article 7 of the ICTY statute, which is what the tribunal has to interpret primarily. It is, we say, it falls within that kind of otherwise assists or otherwise contributes category, which enables, in this particular context of war crimes and crimes against humanity, which by definition are or certainly historically by definition have been large-scale, systematic, and based on policy decisions of large organisations or states, to enable criminal liability being visited on those who were knowing participants in that regime.
So where does I think you told us earlier that the specific concept of instigates or otherwise participates in the qualification directive was specifically, so to speak, reflected in the ICC statute, although not in the ICTY.
My Lord, what I sought to say is the words otherwise assist.
So otherwise assist, you say, equates to otherwise participates in the qualification directive, is that it?
My Lord, that's what we would say, yes.
Yes, I see, okay.
And of course, what we have in Article 7.1 of the ICTY statute, which Your Lordship has at paragraph 32 of the Court of Appeals judgment.
Sorry,
So, paragraph 32, page 10,
Yeah.
Article 7 of the ICTY statute. That, of course, isn't as detailed in the characteristics or the modes of commission of the crime as the ICC statute, but merely talks about plans instigated, ordered, committed, or otherwise aided and abetted in the planning, preparation or execution of the crime. And as we will see, the case law has read the concept of joint criminal enterprise into the word commit. But if joint criminal enterprise is an aspect of the commission of the crime, then in our respectful submission, there is significance in the wider meaning that comes with the ICC statute. The otherwise assists or otherwise contributes.
Yes.
And as Your Lordship, my Lord Hope pointed out, it is in paragraph 119 where the Court of Appeal crystallises its decision and where the Secretary of State kind of takes issue with the kind of narrowness of the focus, which we say is contrary to what is provided for in 1FA as read by reference to the international instruments and the international case law, and is inconsistent with a long line of established jurisprudence in other jurisdictions and the approach taken by the UNHCR.
Could you just point to the particular bits in 119 that you say are too narrow?
My Lord, the particular aspect of 1192 is the requirement for a significant contribution to the crimes commission rather than to the common purpose. And the same in the sense to 3 must have been with the intention of furthering the common purpose rather than perpetration of one of the crimes provided for in the statute, because that, in our respectful submission, places insufficient significance on the very nature of the crimes we're concerned with, namely war crimes and crimes against humanity, and the fact that they are committed by an organisation as part of a system or a plan, so that the large-scale nature and the organisational nature of those crimes, and it ignores, we say, the fact that the contribution needs to be a significant contribution to that organisation's common purpose, rather than...
Sorry, what's the common purpose of our organisation?
So the common purpose of the...
Well, the organisation that you say we're dealing with here. I mean...
Well, the common purpose is, on any activity, is, in a sense, the furtherance of its aim, which Your Lordship put to me was independence and the achievement of an independent and racially pure Tamil state, that is the ultimate objective, and it is similar in that sense to, if one looks at some of the ICTY, and the crimes are being committed as, in light of the evidence, as a necessary part of achieving that aim.
So the common purpose is to commit such atrocities as will further the wider aim, is this it?
My Lord, the common purpose is to achieve by whatever means the objective, which is, as your Lordship put it to me, the achievement of an independent Tamil state.
I think it was my Lord Walker.
Well, my Lord, and of course, as my learned friend Mr. Dillon rightly points out, it is, if one wants to take it down, of course, the common purpose is also the policy or systemic decision by the organisation that in order to do so, it is appropriate and right to commit war crimes and crimes against humanity. Because in the definition of those crimes, it is, as your Lordship will see from, for example, the ICC statute, it is an element that they are either systemic or based on a policy. I'm not sure we have that in the Court of Appeal judgment. That the reference is in the ICC statute, volume 4 of the authorities at tab 33.
We haven't yet looked at this.
No, my Lord, we haven't. That's the ICC statute.
This is volume 3, 33, is it?
Sorry, volume 4,
Sorry. Yeah.
tab 33. And your Lordship will see the reference in Article 7 on crimes against humanity.
So there are separate definitions.
Yes, well, we there have, but it's when committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. Murder, extermination, enslavement, deportation or forcible transfer of populations, imprisonment or other severe deprivation of physical liberty, torture, rape, sexual slavery and forced prostitution, persecution against any identifiable group or collectivity on political, racial, national, ethnic and other grounds that are universally recognised as impermissible under international law, enforced disappearances, crime of apartheid, other inhumane acts of a similar character intentionally causing great suffering, for the purpose of one, attack directed against any civilian population, and that's then sets out the
Definitions.
the further definitions. And again, your Lordship will see, and your Lordships will see in 2A, the pursuant to or in furtherance of a state or organisational policy to commit such attack. And we would respectfully submit that if one has to, for this purpose, in this context, look at a common purpose. The common purpose is that policy, which is what I described earlier, as a policy decision to use whatever means, including the means of war crimes or crimes against humanity, to achieve the aim, the ultimate aim of the organisation.
I have the impression that if you read together Article 25, is it C and D or 2C and D plus 30, the line of thinking is rather along these lines, that the individual who contributes to an organisation's activities in the knowledge that in the ordinary course of events they will include what we see described here in Article 7, then that's sufficient.
Well, yes.
So the purpose, the word purpose you used really has to be unpicked a bit to see what it is that's necessary to achieve that finding. So you look to see what the individual is doing, the state of knowledge as to what is likely to follow from what he's doing,
Yes, my lord.
and see whether that will include what we see in the definition.
My lord, that's certainly right, yes.
So that it, on that view, I think I can follow the narrowness of the proposition in 119, which it doesn't look at it in that way at all, as I understand it.
No, my lord, it doesn't, but focuses on the individual crime, and what is required if one reads them together is that in this context, with the other voices, one needs to step back and look at what is the contribution to the organisation, which enables, directly or indirectly, enables the organisation to continue to commit those crimes. And of course, again, we have this reference to plan or policy in Article 8.1, which defines war crimes. As part of plan or policy.
Yes.
And we see the long list of potential war crimes, which again, the breadth of that definition, one needs to read across the evidence we have in this case as to the activities of the LTTE in pursuance of its stated political aim, namely an independent state.
And which ones would you highlight? I mean, B2 looks pretty obvious one.
My lord, in
War crimes.
well, my lord, we've certainly got B1 and 2.
Yeah.
We have 4, intentionally launching an attack in the knowledge that such attack will cause incidental loss of life or injury to civilians, which would be clearly excessive. Attacking or bombarding by whatever means towns, villages which are undefended, which are not military objectives. Killing or wounding a combatant who, having laid down arms, having no longer means of defence, has surrendered at discretion.
How do we know about that?
Well, my lord, we have the evidence in the war crimes report about torture of, as I recall it, of torture of policemen and other officials of the state. We have, for example, at 413, the reference to mistreatment of prisoners of war.
Sorry, 413.
413, my lord.
What does it say?
Although the LTTE prides itself on its military discipline, there have been many occasions when they have been responsible for the mistreatment of prisoners of war. In the aftermath of the siege, the police station in Batticaloa, 1990, around 600 surrendered policemen were executed by the LTTE. In a similar incident, 400 surrendered soldiers were massacred following the capture of an army camp. Prisoners from the Sri Lankan...
Do we have a date for that?
Sorry, of the
400. I mean, the 600 was was before he ever joined as a 10-year-old.
My lord, yes.
Well,
I would need to. We have at paragraph 36, for example, the 600 police officers. Footnote 36. The report is of 2003. I would need to. I don't have that here. Would need to check. Footnote 38, which refers to prisoners from the Sri Lankan security forces. The forces having stated that they have been subject to torture, being hung upside down and beaten, having pins inserted beneath their fingernails. It appears was a report, a US State Department report of 2000. So they spread the whole range of of the time we're concerned with and before. And we then have going back to the definition of war crimes. We have X potentially if there is the torture is made out, but
10, you mean?
yes, well, it's 10. Sorry, and then there's of course 11, the killing or wounding treacherously individuals belonging to the hostile nation or army, which is the suicide bombers smuggled into Colombo or elsewhere.
I don't think you have to go as far as that. It's 2A little 2, isn't it? Because there are one or two things that are just so appalling that they're in A, whereas B is other things.
Yeah.
So,
Yes, my lord.
So torture is caught
My
at
lord,
the
yes,
very beginning.
I think I was directed to B, but that there are some which, I mean, just going through the list in B, there are a large number which could apply, but of course there are a number of elements of the of 2A, the grave breaches of the Geneva Convention, which are equally applicable. And there's finally perhaps under B, my lords, and I can't claim that this is comprehensive list, but there's of course 22.6, conscripting and enlisting children under the age of 15 into the national armed forces or using them to participate actively in hostilities. And of course there's ample evidence recorded here and elsewhere that there was an LTT policy to force every family to surrender one child in order to fight in their army, and that plainly is. And he wasn't one of those children, but he, one assumes, must have been at school with a number of those children. Having said the first thing, that was he was put into a training school with other children. That is plainly all capable of falling within the definition of war crimes.
But supposing that he himself had been recruited in that way, he remains a member of the organisation once he reaches 18 and continues. And he sees children coming in on the same basis as he himself. And he remains in the organisation and presumably may even serve alongside ones who've just been brought in that way. And he knows that. Is that enough to make him guilty of...
That certainly, in my respectful submission, would be enough to make out the component of knowledge. The question then is, and that's why we come back to one of the questions, one of the 6 factors, is his role in the organisation. If he is a mere foot soldier and he is sent in the first line with all of them, then that may not be enough. But if he is somebody who commands a group of 9 or a group of 45, or is the second in command of the combat group, then and he chooses to stay within the group, despite having for the last 5 years been thinking about leaving the organisation, then in our respectful submission it may well reasonably lead to the conclusion that there are serious reasons for considering that he is forced to be excluded.
So if you're in the combat unit, which includes some of these people, and you're commanding that unit to go out into the field and conduct ordinary military operations, but nevertheless using these individuals, then that's enough, is it?
Well, my lord, if it is done in knowledge of that policy, then it probably is, my lord, yes. Because what it does is it provides a necessary element in the chain of command, without which that common purpose could not be achieved. And it's I mean, there's in the case of Tadic, which I will just briefly have to take your lordships to, there is a reference to a very early decision of one of the Allied tribunals in the Einsatzgruppen case, and there the reference is made to the cook on the pirate ship, and the fact that he has never swung cutlass at anybody doesn't mean he can escape liability for the activities of those with whom he was associated, and that's not just because he was a member of that organisation, but he shared in their common purpose.
I mean, Doesn't it get a bit dangerously close to so to speak, overlapping with the Article 28 responsibility of commanders and other superiors? I mean, I quite see if you're in a position to put an end to it, or indeed to punish those who committed these things. Well, that's one thing, but
or otherwise stop. I mean, I mean, again, one of the examples where the Canadian courts found the decision below being unsatisfactory and overturning it was in relation to a foot soldier who stood guard outside a prison where somebody was tortured, but where it was clear that he neither had a key to the prison, nor had he any way of interfering with the two lieutenants who went in to commit that torture. Now, that may all be relevant. That's why we say the 6 factors are important to look at the scenario as a whole, in order to decide whether the picture as a whole means that he was a knowing participant in that common purpose.
If one starts from the position that something more than mere knowledge is required, then the emphasis has to be on what is that further ingredient. Would you accept that there must be a measure of control or the ability to influence the activities?
My Lord, no, I'm not sure I would. I'm drawing back to the example I gave of the cook on the pirate ship, which is part of is used as explaining the reach of that concept under the Nuremberg, the Charter of the Nuremberg Tribunal. No, my Lord, I don't think I would, because of course it is unlikely that the cook had any way of influencing the decision on any individual attack or the overall policy. And of course the focus is on the policy of the organisation rather than on the individual attack as and when it is being committed.
Well, is the extra ingredient capable of any definition at all?
My Lord, as long as there is knowledge of the common purpose and there is continued voluntary membership, it certainly isn't part of my case that there is a necessity for more.
Well, I wonder whether that can be right, actually, because if you look at Article 30 again at page 16 and 17 in the appendix, I thought it made it perfectly clear that as far as the ICC statute is concerned, knowledge alone is not enough. There's got to be intent as well. Of course, intent is defined in 2 A and B in a very particular way, but you can't get away with just simply membership plus knowledge. There's got to be more.
My Lord, that's, I think, why, and plainly my fault, why I place the emphasis on voluntary continued membership, because it in our respectful submission, that applying the low standard that is required under 1FA, if somebody is capable of leaving the organisation, having the knowledge, but continues to stay there, continues to receive promotion over, in this case, a period of 5 years, in our respectful submission, that is ample material to form the view that there's serious reason for considering that he did intend, or had the necessary intent to engage in the conduct, or to fulfil that mental element.
If it was in a domestic situation, if you take this sort of typical sort of domestic thing where a group of guys go out on a Saturday night or something like that, and they get drunk and so on, and they go and they find somebody and they attack him. Let's say four members, a group of 4 people. Now, 3 attack him, 1 stands back. In that situation, the guy who stands back isn't usually thought of. If all he does is to stand back, he's not usually thought of, even though he's spent the evening with them and he's been there. So he's not usually thought of as being jointly liable for the attack. But if he says go to it and encourages them, then even though he doesn't actually do anything, he is, because he's associating himself with the attack. And so, I mean, I just don't know whether that is the kind of thing which one's got.
But, my Lord, in my respectful submission, that comparison lacks the policy element, systemic element, that is an inherent element of the crimes we're looking at. If those four guys went out with the intent of picking up a drunk and taking their frustration out on him, and one then stands back, the scenario, in my respectful submission, would be very different.
The phrase that... I'm sorry, I interrupted you.
No, I was going to say even in domestic law.
It would, yes, I agree.
Of course, the concept... but I think it is important not to lose sight of the fact that we're here concerned with very specific, very grave and very kind of policy-driven or systematic crimes, such as war crimes and crimes against humanity, which is why I think the policy element in your Lordship's example would be a necessary component.
The phrase that seems to have found favour in Canada, and you may be taking us to that in due course, is knowing personal participation. And that must mean participation in the crime, not participation in the organisation, I think. You think that's too narrow, do you?
My Lord, yes, I do, my Lord. That in our respectful submission, the test is personal knowing personal participation in the plan or the objective, which is of course which may not involve as such that crime, but that crime is a foreseeable extraneous or a foreseeable consequence, but which wasn't part of the plan.
Was a part of the plan.
It was not part of the plan, but was foreseeable as a possible consequent next step.
Well, are we going to the Canadian cases? I'm sure we are.
My Lord, I was going to go to Gurung and then to the Canadian cases.
Well, in view of the time, I wonder whether we should break for the short adjournment just now. But I wonder how your time is going. You asked originally for 3.5 hours, and I think you've had 2.5.
My Lord,
we've been asking a lot of questions, so I don't blame you at all. But
I'm nowhere near as far as I had hoped to be. I will over the short adjournment see how far I can tailor what I feel I have to say in order to make sure I make my time estimate. But I
don't think you should feel too constrained by that. But it's important you should finish before we conclude this afternoon. We need to be introduced to the cases. But
yes, my Lord. Yes.
Yes, I don't know how. Well, we look forward to seeing you at 2:00.
Grateful, my Lord.